Hello, everyone. Can you hear me?
Yes, I can.
Yep.
Hi, Art. Megan.
Hi.
Hi, Bill.
Okay. Okay. Well, I saw Beth a moment ago. Where'd you go, Beth? Bill, are you seeing her?
She was on for a second and then left.
Okay, well, let's see. She's still trying to get in, I'll bet.
There was a Spectrum alert that they were offline earlier today. I hope that's not what got her.
Gerald. Okay. Hey, Beth, are you back on? Whose last four digits are 9107?
Marissa?
Marissa. Okay. Oh, there she is again. You getting back in, Beth?
I know, it did that last time too. It boots me out, kind of like my phone today. Just like kicks people off.
Okay. So, Bill, tell me if I've missed anybody. I have Greg Smith, David Flores, Usha Devi, Gerald Burgess, and Marissa.
Oh, Matthew Whittington just.
Okay. Matt Whittington just came in.
Marissa's with us.
Yeah, Marissa is with Sage Management.
Oh, okay.
Yeah, Sage Management.
Okay, sorry, but I didn't realize that. Okay. Okay. Anybody else popping in here? Last four digits, 8381.
It's good.
I'm sorry, I didn't understand you. Who is that?
It's Gerald. Gerald?
Oh, Gerald. Okay. Okay. Got it. And Gina. Okay. Okay. So far I have Greg Smith, David Flores, Usha Devi, Gerald Burgess, Matt Whittington, and Gina. Have I missed anybody? Okay, so Jimmy, you're gonna be my timer tonight.
Yes, ma'am. Ready to go.
Okay, yeah, okay, I'm gonna go ahead and call this meeting to order, and we're gonna start with public comment. So Greg Smith, did you wanna make a public comment or a comment about an agenda item?
No, ma'am, I didn't want to make any comments.
Okay, David, did you wanna make a public comment or a comment about an agenda item?
I wanted to make a comment on agenda item number 7.
Number 7, okay. And Usha, did you want to make a public comment or a comment about an agenda item?
No, ma'am. Thank you.
Okay, and Gerald, did you want to make a public comment or a comment about an agenda item?
Not tonight. Thank you.
Okay, and Matt Whittington, did you want to make a public comment or a comment about an agenda item?
Not tonight, thank you.
Okay, and Gina, did you want to make a public comment or a comment about an agenda item?
No, thanks.
Okay, so David Flores, you have 2 minutes for, and your topic is going to be agenda item 7.
Start.
Thank you, Catherine. So I just want to comment and have the board consider and kind of think this over. I know beautification funds are dollars that are from fines within the Anderson Mill West District that is paying for the lawyers for Amwana. But to me, I believe that that money is public funds, and I believe that the district as a whole should decide what to do with that money. I don't think that your constituents would be too happy that you are using public funds to pay for the lawyer of a neighborhood association. I would just like for y'all to reach out to your HOAs and other people in the neighborhood that are not in Anderson Mill West and kind of see what their thoughts are on it. But if I were in your position and I would look at it as a whole district, I would not agree with giving Amwana more funds to have a lawyer represent them. Thank you.
Okay, thank you, David. Okay, at this point, okay, hold on. Before I close this down, let's make sure that nobody else popped on. So, I just lost my,
Catherine,
yeah, I just lost my thing here. Yeah, keep going.
Gretchen Smith has joined the meeting. You might want to ask her.
Okay, yeah, I clicked on the wrong button here. Gretchen Smith, did you want to make a public comment?
Not today, thank you.
Okay, so nobody else has jumped on the meeting. Okay. Excuse me. So at this point, what I'm going to do is, how come? There we go. I'm going to close the public comment section of the meeting, and I'm going to move to agenda item 2, management report from Sage Services. Does somebody have a screen share that they can do? If not, that's not, if you don't, that's fine. I think everybody received a copy of it.
Yes.
Okay, go ahead.
I'm going to go ahead and start with the summary sheet for March of 2021. We had 25 trash cans in view. We sent 22 friendlies and 3 first formals. We had 15 open storage, 13 were friendly. 1 had a fine and 1 was pending. We had some winter storm issues that we were trying to take into account and give people some extra time to clear up stuff that they had in their front yards that were related to the storm. We had 3 unregistered cars. We sent 3 friendlies for those. We had 5 trailers. There was 3 friendlies. 3 of them were pending. It looked like they were being used to clear debris for the winter storm. We had a recreational vehicle, 1 friendly. We had 6 boats that had come in to the area in the month of March, and we had 6 friendlies. We had 6 fencing and yard issues. There were 3 fine letters for fencing, 1 pre-fine letter, and 2 friendlies. We did have a little bit more on the trash cans and the open storage this month around. There was a lot of cleanup going on in the month of March. We also had approximately 32 outside Sage complaints come in regarding trash cans in view, satellites, and open storage that we had to follow up on in the month of March. So that kind of explained a little bit of why we had a little bit more on the trash can.
Trash can in view this month. Are you still there? Jimmy, Diana, are you still there?
Had been brought in from the
Okay. We had sort of a long gap there. So why don't you back up about 10 seconds? I think where you were at was you were saying that that you had an awful lot of was it emails or complaints about trash cans in view? Is that what you were saying?
Between 30 to 35 outside complaints come in outside of Sage that we to confirm and verify. Some of those were sent just to Sage. Some of those were also sent to the committee.
Okay.
And that contributed to some of our numbers in the trash cans of view. A lot of the pictures that came in, we had to go out and document. They didn't have a timestamp. They didn't have a date stamp. So in those type of situations, we have to go by and confirm those on tour.
Right. Well, I must admit, I received quite a few emails, and the emails were not helpful because of that. You know, and sometimes just a picture doesn't say 1,000 words. It doesn't tell you anything. So, okay.
Okay, I'm going to move on to the overnight parking violations.
Okay.
One of the things that happened, we had our data dump day was the last Friday of the month, and we still had another tour on the 31st. The 30th and 31st of March, we had 3 overnight parking tours in March. It just so happened that's the way they kind of landed in this month. So the letters are not accounted for in this summary. They'll be accounted for, the numbers will be accounted for in next month because I'm going to have to send it in the data dump for April.
Got it.
Go ahead and send it in a file that says March letters so that it'll be easier to download it into that file. But there were 10 letters on the 31st of March, and one of them was a duplicate because we had to send it both to the property owner and to the tenant. So we had a total of 11 letters go out that I will invoice for in April, but they were out of the March tour. Other than that, the numbers were down. Hunter's Glen, we did 1 tour for them at the beginning of the month before they discontinued their overnight, and they had 1 friendly. Hunter's Glen 2 had 3. 1 was a first formal, 1 was a pre-fine. In section 14, we had 2, and we had 1 pre-fine. Section 15, we had 3 friendlies. Section 16, we had 2 friendlies. Section 17, we had 3 friendlies. We had 1 fine letter in March. Section 18, we had 1 friendly. In section 21, we had 0, but we did have 1 first formal at that time.
Okay.
I can let you know how many we had on March 31st by section if you will need to know that information, or do you want to wait until
I'm okay with waiting until next month. That's fine.
Okay,
You know, it's just a
We do
timing
have a-
thing. Yeah, it was just a timing thing.
okay. We did have 80 letters go out in March. The letters were reviewed by the committee. Everything
You still there? Diana? Diana?
in, but most of them are.
Okay, so let's start again because you cut out right when you said the letters were reviewed by the committee and then nothing for, until just a moment ago.
Okay. I don't know what's going on. Maybe it's Spectrum. We have Spectrum and they've been experiencing issues all day today. But I wanted to go ahead and say that we had 80 letters in total for March, and all of the letters were submitted and run by the committee, and then they were sent to the legal. Any questions that we may have had on interpretation of a deed, we ran it by legal before we put it in the letter, so that that was accounted for before the letters went out, not after.
Okay.
So we had 80 letters total. The pods and dumpsters that we have in the neighborhood are mostly related right now to the winter storm damage. We have 3 or 4 that had several pipes burst, and they're having extensive remodeling done. And that is why we're seeing those pods and dumpsters in the area.
Okay. Well, depending on the severity of the damage, they could be there for a month or so.
That's what we're looking at. They're having to deal with insurance companies and contractors. So, and everyone is really
Busy.
stretched right now on the contracting side, trying to get these remodels done. So they might take a little bit longer than usual.
Yeah.
That's what I have on the monthly summary of violations.
Okay.
We have some pending appeals that's next on the agenda. I don't know if you want me to move forward from here, or if you want
Yeah.
to discuss the summary.
Yeah, let's go. Let's talk about the appeals. Agenda item 3.
Okay, we have one appeal on Peppergrass for a trailer. The committee has seen the copy of the appeal, and the board is going to make their recommendation to the board. I mean, the committee is going to make their recommendation to the board on that one.
Okay.
It is a first time fine, and they are in complete compliance right now.
Okay. Okay, so the situation we have is we have a first time fine, and the resident is in compliance and he understands what the rules are. You've been in contact with that resident?
With the resident, the landlord, and the owner of the property.
Okay.
So everyone's on board now. With the
Okay.
rules.
So I move that we waive the $100 fine for the trailer for appeal number 1.
I'll second.
Okay. Do we have any discussion about this? So let me go back and reiterate sort of what our process is that everybody gets a pass on their first fine. And so we're just following the process that we've always had, because in the end, it's all about compliance. Does anybody else have any other comments before I call the vote?
Yes, I have comments. I have questions, actually.
Sure, go ahead.
Where was the trailer?
On Peppergrass, on the side of the house.
And where is the appeal letter stored?
The committee has the appeal letter right now. The data dump isn't until the end of the month. And so it will be sent to legal at that time.
So legal is storing all the appeal requests?
Right now we're sending everything to the cloud storage that Bill is handling?
I'd like to see the appeals before you ask us to vote on them. I don't know why they can't be attached to the emails that Bill sends out prior to meetings so that we can actually see the appeal.
Well, we're
And
trying.
if we don't have access to the rest of the information, then there's no way for me to know if that was the first time they appealed. I don't know what trailer we're talking about, or how many times it was seen, or how many friendly letters they got. There's not enough information to make a decision.
Catherine, the protocol at this time is that the appeals go to the committee.
Right.
And they give a recommendation to the board.
Right.
If the committee is unanimous in their decision, they can put forward their recommendation. If they're not unanimous in their recommendation, then the board is provided the information so they can weigh in on it. That's the way the protocol is written up in the rules.
Correct.
Okay. The I don't perceive this particular appeal to be a controversial appeal, in the sense that we want to waive this fee. It's a first time offense, and we've got buy-in from all the related parties. So
Yes.
I'm going to go ahead and call the vote. Beth?
Yes.
Linda?
No, and for the record, it's not appropriate to ask us to vote without all of the information.
Okay. Megan?
Yes.
Art?
Yes.
I vote yes too. Okay. Appeal number 2. Go ahead.
It's on Brighton Bend. It is for trash can in view. They got a fine on April the 7th. The appeal has been submitted. The committee has reviewed it, and it is a first time fine. They will be in compliance from now on, that they understand the rules. There was a question as to whether they were bound by deed enforcement because they weren't sure that they were in the mud.
I verified that before the meeting.
Paying taxes. So
Yeah.
I don't think the claim that they had that they DRCs weren't filed with their property is part of their situation here. But it is it is their first time fine, and they've asked for it to be waived, and they have said that they will be in compliance.
Right.
True.
So I'm going to make a motion that for appeal number 2, we waive the $100 fine for Brighton Bend. Can I have a second?
I'll second that. Okay.
So do we have any more discussion?
Again, we need to see these appeals if you're going to ask us to vote on them.
Okay. I'll go ahead and call the vote. Linda?
No, for the same reason. Without all the information, you should not be asking us to vote.
Okay. Megan?
Yes.
Art?
Yes.
Beth?
Yes.
And I vote yes too. Okay. Okay, so those are all the appeals, correct?
For the appeals, you
Okay.
had a few that you had for review, the committee had for review. I don't know if you all want to discuss them with the board. where they're
Yeah,
at.
well, yeah, so let me take over this for a moment here. So Bill, can you give us an update on what's going on at 27, on Tierra Blanco? We've got the issue with on Tierra Blanco.
Are there any current violations?
Yes.
Yeah,
In
we've got,
March 3rd, there was an open storage and a maintenance violation, 200 on each one. And then on the 7th of April, there was a maintenance violation for 200.
so this is where I understood is that, you know, we went to court, they didn't show up. We had a judgment. It's like, I'm not interested in accumulating fines. I'm interested in figuring out how to come into compliance. So, what's next? That's what I'm trying to ask.
Okay. So we did get a default judgment. The judgment's now final. It has not been appealed. And so we're in the process of getting a writ of execution along with abstracting the judgment.
Okay. I don't understand what that means. So what's a writ of
Writ of execution is issued by the court, and typically the constable will go to the address to collect the judgment. This owner owes the district attorney fees and court costs. The judgment also has an injunctive relief provision, and we'll also execute that as well. We
Okay.
have sent a copy of the judgment to the owner, so they're aware of it.
Okay. So tell me, what does, as it relates to trying to come into compliance,
That's
what does-
the injunction. Yeah, that's the injunction.
yeah.
If a person fails to comply with an injunction ordered by the court,
Okay.
it could be held in contempt. We could file for contempt charges, which is a criminal charge.
Okay. Well, okay.
So do we keep monitoring and taking photos every time if it still continues at this point, or?
Yes. The judgment does not affect your enforcement via fines, so you continue enforcing just as you would before.
Okay, thank you.
Is it appropriate for us to try to set up a meeting with this resident so we can come to a resolution on how to move past this?
Well,
I mean,
sure, if you can get them to respond. They've never responded to us.
Haven't we attempted that with the letters and whatnot? Invited them to join the meeting and.
I mean, I
Okay.
have, the lawsuit is essentially concluded, so I don't have any problem with the committee reaching out to the owner if you want to. They've never responded to our office.
Okay. Okay. Okay, I don't have anything more any more than this. I think the committee is going to need to have a meeting with you, Bill, to come up with a strategy to move forward. Okay.
Agree.
Okay. So the next house that that we have to discuss is on Birch. And I think we do have an appeal from this resident. Am I correct, Diana?
We did not have an appeal per se on this. We had an email sent to us for the former violation of the open storage, and we voted on a payment plan. There hasn't been any payment plan put in place by the owner of the house. Since then, we have had a new violation of maintenance. And there are now 3 fines on that property. And we did have an email from the resident talking about that they were going to get the fence and everything cleaned up by the end of March. And on April 7th, it still was not in compliance. So I'm not sure. There isn't any formal wording on there asking for an appeal, but I've emailed it to you all, what you all wanted to do, if you wanted to accept that as an appeal. At this point, the violation, the maintenance is growing and getting a little bit worse by the day. So I don't know how you all want to.
Well, right now where we're standing is we're still not in compliance. And so, you can't appeal something until you've come into a compliant state. So, and I think we're dealing with what? Trees down, limbs down, foot grass, it's getting worse. Am I saying that correctly?
Yes.
Okay.
And The gate that needed to be repaired, when we went by, it was not, they just had a piece of, like the gate was just, or a pallet was just leaning on the fence. It wasn't a repair. I sent you all the pictures. You all can make your decision on that.
Right. Well, at this point, we're just going to have to keep reaching out to them to come into compliance because we can't entertain any waiver of fines until we get compliance, which is really all we care about. Okay, so the next one is we've got overnight parking on Lobelia.
Yes. We've had 3 violations, one on the 18th, one on the 31st, and one on the 14th.
Right.
The one from the 18th was an accumulation of a personal car that had been parked overnight. On the 31st, the car changed into a large commercial vehicle. The owner of the commercial vehicle has filed for an appeal for that fine plus any future fines. But that is not the account holder. So we do not have an appeal from the account holder.
Right. Okay. And right now,
yeah.
Okay. So let me see if I got this right. So we have a situation where we've got an appeal for a personal vehicle, and then or we got a fine for a personal vehicle, and then we got fines for a great big for commercial vehicles. The commercial vehicle, the owner of the commercial vehicle is maintaining that his vehicle is a first responder vehicle, which we have determined is not correct, which is why he asked for future fines to be waived. And then to make it all the more complicated, none of these people are the account holders.
No.
Okay. So at this point, we're gonna have we reached back to them and asked for the account holder to make an appeal and resolve the problem?
When I communicated with the person submitting the appeal, I let him know that the appeal had to come from the account holder. Since then, we have also checked on the CAD, and the account holder is no longer listed as the property owner.
Okay.
So we have a property owner, an account holder, and a resident that is the one filing the appeal. There's 3 separate people.
Okay.
And I don't have anything from the account holder at this time.
Okay, so Bill, give me some guidance here. We've got an account holder who doesn't live in who doesn't own the property. He doesn't live on the property. We've got how do we handle this? Because I'm still looking at this from following the rules that the account holder is ultimately responsible. The appeal has to come from the account holder.
And so whose vehicle is it?
That's not the account holder.
Is it a person residing in the house?
It is.
That's our understanding. Yes.
Yeah. It's an employee of Texas Gas parking his commercial gas truck in the street, and he resides, at least it appears that he is residing there at this home at this time.
But the account holder actually lives there too, is leasing the house?
No.
No.
Account holder, his name is still on the account, but he sold the property to somebody else.
And we didn't know that it got sold?
No.
And Infomark didn't know and didn't change the account?
Apparently they don't. I mean, we looked it up on the CAD and we pieced it all together when we saw 3 different last names.
Okay, so the former owner of the property, it's not his vehicle. He doesn't live there anymore. He just happens to be on the account, and that's an error. So we can't, we're not going to be waiting for an appeal from that person, obviously. They're not involved with the property. It's an error that they're still on the water account. That should have been changed.
Okay.
So the people that are subject to the enforcement are the resident person that owns the vehicle that's residing there, apparently is leasing the property, apparently, and the owner. So we could accept appeal from either of those two people. So
Okay.
Bill,
they're
the owner that is listed on the CAD has the address that is in the district. So I sent a letter to the owner at that address, and I sent a letter to the resident that made the appeal at that address, and I sent the letter to the account holder. So I was covered all three ways.
Yeah, but the account holder is not relevant. That's just a mistake. So either the resident or the owner could appeal the fine. So the person that's residing in the house can file,
Okay.
they can file an appeal.
Okay, so let me ask some more procedural questions then. We know we have a situation where the account holder is not the person living in the house and is not the property owner, and they're not a tenant. So what is our protocol for forcing an update to the water account?
Well, typically Infomark will contact them and tell them they need to fill out a service agreement. And if they fail to do so, they're receiving service without authorization. You could turn off the meter. You could turn off.
Okay, okay. So that's what, okay, so that's what we're going to do for this particular, is we're going to instruct Infomark to go get a service agreement for the new property owner who is living in the property.
Well,
Is that
who's ever living in the property probably is going to pay the water bill, so they probably need
okay?
to file the service.
Okay, I'm writing this down. Okay, so then, okay, so now let's back up, Diana, since we've got appeals from the people living in the house, correct?
Yes.
Okay, so what we've got now is,
And it is an appeal for past fines and future fines, but you have an overnight parking violation and you have a commercial vehicle violation as well.
okay, well, what have we heard from them about the overnight parking? Because I know that the guy who wants to park his commercial vehicle on the street and claim that he's a first responder, has there been any response from him that we told him that, I'm sorry, you're not a first responder and your vehicle doesn't qualify? Have we had any
I have not relayed that information to him. I was waiting for
okay,
meeting so that the board could give me a directive on how they want to move forward on this.
okay, well,
It was such a complicated situation with
I know.
who's the account holder, who's the property owner, who's the resident.
yeah,
And I didn't want to make a step without Bill weighing in and giving us some direction on it.
okay,
Hey, Catherine,
yeah,
so let me clear this in my mind. So there's three parties here, right? There's the owner of the home, the people that are actually living in the home that filed the appeal, and then the account holder. Is that correct?
yes,
Okay. Now, the account holder no longer has an account there, right? He didn't own the property, so he's gone. So we don't have that person really. We don't really have the people that live there and file the appeal aren't registered with Infomark. Is that correct?
correct.
That's correct.
Okay, so this is my suggestion. My suggestion is that we waive everything on the condition that the current owners or residents of the account of the property set up an appropriate water account. And then we'll move forward.
No.
Okay,
then,
so who are we gonna waive it on though? That's what parties
we're
do
gonna-
we waive?
well,
You
yeah,
do The first fine like we usually do, and
nah,
then we see if they take care of the paperwork for the second and third fine.
okay, say that again. You were saying waive the first fine and then we'll use the carrot of the second and third. We'll waive that once they set up the account.
That's what we've done in the past.
Okay.
I
I'm
don't know.
okay.
I don't know if that's what you want to do. I'm just saying that's what we've done in the past.
Well,
I
I'm,
wouldn't waive anything until we get somebody who actually is registered at that address with, with a water bill, you know? I don't know, it seems suspect to me.
well, it's bizarro. I must admit. I guess I'm much more anal. I would not have moved out of a property without shutting off my utilities because I don't want to get the
Exactly.
bill.
Are the violations corrected at that property?
No, not yet.
Then
They're
why
not
would you consider waiving a fine?
So, okay, well, wait a minute. We don't know if they're corrected or not.
We had a violation on the 14th, which
Oh.
was
2 days ago, you're right. Okay.
So who's
So,
the violation against? The owner or the people living in the property?
Commercial vehicle.
the commercial vehicle that is asking for future waivers. They want to stay parking there all the time,
Yeah.
overnight.
yeah,
And they're the ones that actually live there but don't have an account set up, correct?
yes, yeah. Okay,
It appears
So-
that they are guests of the homeowner at this point because the driveway is full of cars. And it's a totally different, all three names are totally different.
okay.
See, my opinion is different. We should contact the homeowner and say, you're responsible for getting these people to sign up and have the water bill under their name. So, the fine goes to you if they don't comply. I just don't understand why that homeowner wouldn't make sure that they were registered as people,
Yeah.
receiving the water
Get their,
bill.
yeah, get their name off the account.
Exactly.
Okay, so.
I like Art's idea. I think that's great.
Okay, so we've got a couple of things we need to do. First, we don't have compliance. Second thing is that we need to get the account set up by whoever's living in the account, living in the house and is a property owner. And correct me if I'm wrong, Diana. The property owner is living in the house. They just don't have the water account in their name.
That's my understanding, yes, because when we
Yeah.
look,
Oh, okay.
they have that same address listed.
Yeah, so the property, so the account holder doesn't live at the property and doesn't own the house, but he's somehow going to be responsible for the water bill. Like I said, it was just
So
one of
there's
those
really
things.
two parties involved. There's two parties involved.
There's
Because the homeowner's living there. He's the
I
one
think-
asking for the appeal, but the water bill isn't in his name.
Isn't
Right.
in his name.
The homeowner is not asking for the appeal. The person that owns the commercial truck or the employee of the gas company is the one asking for the appeal.
Mhm.
I know, but doesn't he live in the home?
We don't know. We just know it's parked there.
God,
Well, we know.
I have a headache.
Vehicles parked there overnight and you're wondering if the person's living there. I think that's self-explanatory.
Yeah, we can make that assumption that he's living there, for sure. But I guess my question is, it goes back to the homeowner. One, he's invited. Why isn't he switching his name, putting his name on the water bill?
Yeah,
You know,
yeah.
I mean,
Okay,
to
so
me, that's fraud because he's using the guy's water, the one that's on the account bill.
it is,
Geez.
I know, it is just, you couldn't write this stuff. Okay, so let's do this. Let's say we are not going to waive anything at this time. We want to get once the account is set up in the name of the people who either live at the house or own the property, then we will come back around and address the appeals. and we need to get into compliance, and we're going to have to convey to the gas employee that his vehicle is not considered a first responder's vehicle and it needs to be parked in the driveway.
Okay.
Okay.
Now, the address is on Birch, correct? This is the
No,
home
this is on Lobelia.
Mobilia, that's right.
Yeah, this is on Lobelia.
I will reach out to him right after the meeting.
Okay. Okay, so now,
We'll need to reach out to Infomark to let them know to,
oh yes, I've written that down. I will follow up after the meeting that that we need to get the account set up. And I think it's Bill, is it an appropriate thing to do to red tag the house in order to get their attention that they need to properly set up service?
Well, I think typically what Infomark does is they try to contact the owner first to
Okay.
get it set up. And if there's no response, then they could red tag it to
Red
turn
tag.
it off for no agreement.
Okay. Okay. So how long? What do you think the appropriate timeline is? You know, if-
I'm not sure whatever Infomark has been doing in the past.
Okay, we don't have any Infomark people on the account. I'm going to say 1 week. I think that because they've been in the house, this has been going on for more than a month, hasn't it?
the overnight parking fines go back to the first of the year, yes.
You want to say 10 days?
Yeah, 10 days.
That gives them 3 days to get it in the mail.
Okay.
It gives them 6 days to take care of it if they get it on a Friday or whatever. But
Okay. Okay.
Before you move on, Catherine, Bill, can you tell me where it's written that the water account has to be in the name of, I don't know, the person who's living there, the person who owns the property, the renter, the landlord? Where's
Yeah.
it written?
Well, the account can be in the name of anyone. They're the person responsible. Right now, however, the person that's on the account doesn't own the property and has moved away. So typically you would get a notice from the person, hey, I sold my house, terminate my service. That didn't happen. What happened is people have moved in the house and they haven't turned on service. So they're essentially receiving water illegally because they haven't hooked up.
Are they related?
Pardon me?
Are they related by chance?
I have no idea. I don't have any of this information.
Well, I was going to say, because what if like the parents let their children move in, so the
Yeah.
parents leave it in their name, you know? I mean, I don't know the details either. Precious little information, but wouldn't we need to know more details before we demand them to change accounts into their name, what have you?
Well, I guess if the person that's on the account is paying the bill and they don't care, I guess it's less of a concern, but
Why should it? Why should we-
typically when a house is sold like that, and the person's moved out, they don't believe they're responsible for the account. This may be one of our delinquent accounts that are going to cause us trouble when we contact that person. So I think that Infomark contacting the owner that's living in the house to request that if the prior owner is not committed to paying the utilities indefinitely, like I can't imagine it's true. Maybe if it's a parent selling a house to a child, maybe, but typically this just happens. People are careless in their move outs.
We don't know if this is a delinquent account.
I have no idea.
We don't know that.
No, I don't.
That's
I don't
worth
have.
knowing. Is this a delinquent account? Is this one of the very delinquent accounts?
Yes.
and we're working on that.
I'm sure Infomark could check that out before they contact these people.
I think we would need to know a little bit more details before we start interfering in how people set up their accounts.
Well, Linda, they can set it up however they like.
Right. That's
But
what I'm saying.
if they're getting free water because they haven't set up an account, then that's a problem.
Well, true that. That's what I'm saying. If it's a delinquent account,
But
it's a
these people
whole.
are taking action, they're filing it for an appeal, and we're trying to figure out who the appeal goes to, so.
Right. If they're
really,
paying their water
the
bill,
ball's
though,
in their court, you know.
if they're paying their water bill, if they are not delinquent, then it shouldn't matter whose name it's in. Would I be right?
Well, it will.
Yes.
It will on the appeal process, possibly. I feel, I don't have any information on how many details I admit it, Linda, but I feel pretty confident this is a situation where the house got sold, the new people moved in, and the water still ran, and they never contacted anybody to put it in their name. I'm pretty confident this has happened a lot during the pandemic, a lot more in other districts where people move in and we don't even know they're there. They haven't signed up. We find out the last tenant moved out 3 months ago. So I think Infomart contacting them to ask them, are you a new owner? Do you need to set up an account, that kind of thing?
I don't have any issue with that, but I do want details on that account. I want to know if it's a delinquent account. I want to know if the people have been paying the bill, that kind of thing.
Yeah, I agree.
Just more details. Doesn't change what Infomark is going to do going forward. I just want more details.
Yeah. Okay.
As do we all.
Yes. Yeah. Okay. So the next house that we have to talk about, or the next account that we need to talk about, is we've got the issue of the disabled veteran on Melba Pass.
Yes.
And so this is, and Diana, tell me if I'm getting all of the facts laid out here correctly. So at this stage, the resident has registered all of their vehicles
Through August.
through August.
It was a partial registration. They just brought it up today and they will have to register all the vehicles again in August.
Right. Okay. So, and they have fines for unregistered vehicles, and they have fines for overnight parking, and we have waived fines in the past. And so what I am suggesting,
And the board, you all voted on a payment plan.
right?
And they have not initiated or put forward any activity to try and set up that payment plan at this point. What they have done is they are appealing the payment plan decision.
Right. Well, it's even, they also have not paid anything since last September. And so this is the suggestion that I'm going to make. The suggestion that I'm going to make is this, is that we put all of their fines in abeyance until August, because next August, which is coming up, believe it or not, very quickly, they're going to have to re-register all their vehicles. And so my suggestion is that they get their water bill paid in full and brought current, and we will put their outstanding fines in abeyance. And if they register their vehicles on time, so this problem doesn't come back again, because that's all I care about, I just want to make this go away, then we will waive everything. That's all, because I just want them to pay their water bill and not have any violations. So that is my suggestion.
And you just said they already had their fines waived once, and you have a rule where you only do that one time.
I know that, but we are dealing.
An exception for this property?
I know it is. Linda, I am damned if I do, and I'm damned if I don't. Because if I do nothing, you're going to complain about it. And if I try to do something to be nice to them, you're going to complain about it. So I've decided I'm going to try to do something nice for the disabled veterans. But the problem that I'm concerned about is they were severely in arrears in registering their vehicles, and they were able to register their vehicles for less than a year, which I guess is a privilege for being a veteran, because you and I wouldn't be able to do that. But so it's going to come back around here very quickly. And so what I'm trying to do is hang a carrot out there in front of them to be on top of getting their vehicles inspected and licensed and have it go away in August altogether. But the caveat is, one, they got to pay their outstanding water bill, and two, they got to make sure that they get their vehicles registered again, because I do not want to be dealing with this again next August when all 4 of their vehicles come up for inspection and registration.
Catherine,
So-
I don't object to your trying to be nice and dangling a carrot. I just want you to do it for everybody, not just for some.
Well,
Okay, so does anybody have any other suggestions? I mean, I
Well,
am
Art
looking
does.
for a suggestion.
Well, Catherine, remember in the past, we had a process. Remember that Paul Robigo and I put together, and it was a process of the friendly letters, and then, but there was a condition in there that said, if these people are disabled or have some type of medical condition, then we would put together a special due process for them to do good on their violations, right? And I
Okay.
guess that's what we did here, right? Because they're disabled veterans, so they can't get around. They have a medical condition, I would assume,
Yeah.
correct? Okay.
We don't know that, and that's not written anywhere.
Well, I
That may
don't
be
know that.
something,
I
that may be
don't know
something
that,
you
but
guys did. It's
how
just
did we
not
find
written.
that out? That's my question. How do we know
How do we know what?
that they're disabled veterans?
Well, they keep telling me they're a disabled veteran in our email communications.
Do they have a medical condition? You know, I would assume they would. They could describe that medical condition. But I guess
They have said that they're both on full disability in their emails, but we do not have any proof of it.
Right. And and I'm not interested in going down that
That would be an
road.
accommodation. You would
Yeah.
be doing an accommodation,
Yeah.
and
So
that's a
does any-
slippery slope.
I know it is a frustration. I agree. So does anybody have any other anything else to
Add.
yeah. So
Do we want to do an ask for a letter from them?
asking to describe their
condition?
disability?
Yes.
Okay.
Remember when that lady came to us and she said she had a deaf son and she eventually moved out, but remember she had $4,000 in violations, right? She finally came and described her condition with her son. And then we set her up on a payment plan, which she adhered to, and eventually moved out,
Yeah, I remember that one. And the other one that I remember was the disabled resident who had an electric cart that he
Was in the
was on a
driveway.
trailer. It was on a
Yeah,
trailer.
the trailer for the
And
electric
so
car.
we had a special accommodation because he moved his cart when he drove around on a trailer. I do remember that one.
So why can't we reach out to them and say, please prove to us that you are disabled and you can't get this done? Or do we have those rights? Do we have that jurisdiction?
Well, why don't we do this? Well, let me ask this.
They have a card, right? A veteran's card that they probably carry with them.
I don't know. Aren't there disabled vet plates too? Do they have are there disabled vets plates on anything? Do you have any recollection of that, Jimmy or Diana?
There are plates, but you have to ask for them and pay special for them. Not everybody who's a disabled vet.
Oh,
would
really?
have them.
Oh,
Yeah, you have to ask for them. It's like a special plate.
Oh, I thought maybe that was just something that was.
It's not just given, no.
Oh, okay.
And there is no ID card for a disabled vet that's splashed across disabled. They have an ID card, yes, but it doesn't say disabled.
Disabled across the top, across the front of it. Okay. Okay. So how about I think.
Catherine, I just want to
Yeah.
add that the same 4 vehicles that we are going back and forth with the registration are the same 4 vehicles that we struggled with in 2019 with the overnight parking that were being moved back and forth. They're the same vehicles. They're just stuck in the driveway now instead of being parked in the street. So
Okay.
what
But-
condition and how drivable they are, we do not know. They may be also inoperable. The email states that they were towed to get registered, inspected and registered, and then towed back to the house, which I don't understand how they passed inspection if they weren't drivable to the location.
They wouldn't,
Like you
there's
have a
no way that they
trifecta
can
here.
pass those. They
No.
can't pass them if they're not drivable.
It's just one of those things that we need to keep in mind that the 4 vehicles have been, in one way or another, we've been dealing with them for 24 months now.
Yeah, I understand. Okay.
Well, at this point, I think we should follow protocol and follow procedure and move on with the finding process, you know, because they haven't told us anything that to combat what we're dealing with here. You know, there's no special circumstance that we have details on or anything like that.
And
Okay.
they
Least I
have
don't.
already received a waiver of fines in the past.
Right. And they're not even paying the water portion of their water bill.
We were on a payment, I mean, we voted to put them on a payment plan, but it has not been initiated.
Right. No, it's like right now the water portion of their total bill is not that big. The fine portion of their bill is 6 times bigger than the water portion of their bill. So no, wait, I said that wrong. I added the things up together wrong. Anyway,
Can we reach out to them and find out if they have?
yeah, tell you what,
some type of-
let me write a formal letter. Because, well, let me ask you this: where do we want to stand? Where do we want to end with this? You know, besides appeal, and I want them to pay their water bill.
But you
Yeah,
wanna-
that's
I mean
what it says right
compliance.
there. They
I mean
wanna pay their water
compliance.
bill.
Our
They're in
goal is
arrears.
for them to be compliant, correct?
Yeah.
So let's talk about the cars, and we know that they only have till August to get all 4 of them done. Here's the fines that we have, and
Okay.
let them share with you what they can do and they can't do, and then let's re-talk about this again later.
Okay. So what we're going to ask is that they pay water in full immediately, since they haven't paid anything on their account since September of 2020.
Wow.
Yeah.
They've had 4 unregistered cars since 2019.
How
The
long
cars
is it?
not unregistered in 2019. The cars were in overnight parking violations in 2019.
On the street, they were parked on the street.
2020. Yeah, they were
Maybe
parked
we can get Bill to write a letter and say, unless you prove otherwise, you have to tell us what's going on here, because let us help you, but you got to tell us what you're going through, because
Okay.
obviously.
I would suggest that, Art, you probably haven't been privy to, but I think there are a number of emails from these owners.
Yes.
I've seen some of them. I don't see any reason to doubt that they're disabled veterans. I mean, you could say, okay, are you really a disabled veteran? I don't see any reason to doubt that. I think the reasons that I saw in the emails previously, the ones I saw, were that they couldn't get out to get their cars registered.
Right.
Most of that was because of COVID.
Pandemic. Yeah.
Yeah, the pandemic and the danger to them as being older disabled people. So there was a delay. And then I think the board took that into consideration when we came up with the payment plan. And so I think that this owner really, they need to get on the payment plan that the board approved previously, because now they're coming back and saying, yeah, we didn't get on a payment plan. What I saw in the email that I saw, we can't afford to pay these fines due to our income, which is a different reason. That's not a disability, that's a financial reason. And typically when people are suffering financially, the board considers payment plans, not typically waivers.
Right. Well, and at this point though, like I said, they haven't paid anything on their account since September of 2020. So, we are 6 months into, since they've made any attempt to pay their water bill.
Right. And Catherine, I think you sent me an email asking for an agenda item next week on the delinquent accounts.
Yes.
Perhaps this should be put on hold until you can discuss those accounts. Because I think you're going to recommend consideration of lifting the no shutoff protocol. And I have a feeling a lot of people will be interested in payment plans and paying their bills when that.
Yeah.
I hate to be like that, but yeah, we're gonna have to. They haven't cooperated in any way, shape, or form.
Well, and getting back to circling back to one of the things that Bill was just talking about when I was discussing this whole issue with Lee, we have a number of delinquent, like double digits, like over 25, I think, accounts where a payment hasn't been made in a year. Yeah.
How is that possible? How is that possible?
Because of COVID.
Because we don't.
COVID isn't the answer for everything. How is it possible that 25 accounts have not paid a water bill in over a year?
Because there's no consequences for not paying.
Yeah, because we made that vote that we weren't going to punish anybody during COVID.
And we're not shutting anybody off. We're not red tagging. We're not. There's no fines. There is, and some people.
Payment plans been set up with these account holders?
Per Lee, she's constantly reaching out to them, and they're all ignoring her. And they, yeah.
Well, they're not very effective then.
No, it's not. But granted, it's a very small number of our total population.
Sure.
And there's always going to be that small population. It's like, hey, if there's no consequences, who cares? Okay.
Well, everybody got stimulus checks, so we know that they had it in their hand. It's just how they chose to spend it.
Yeah, that's one way of putting it. Okay, so I'm comfortable waiting until next week, but I also think that I'll go ahead and put a letter together that we can review when we have our meeting next week, so we can determine what we want to communicate to this resident. Now, hold on. Okay.
I would suggest putting a chronology together, saying, look, this is what we've done with you so far, and to this date, you have yet to comply.
Right.
So tell us the story here. What's going on?
Okay, so I think that's the end of it, isn't it, Jimmy and Diana?
Melba Pass was the last one, but just closure here. You want me to communicate to him that the payment plan is going to stay in place?
Yes.
No?
And that he needs to start paying on his water bill.
Okay, and am I going to do all of the communication with him, or were you planning to do some of the communication with him?
I was going to do some of them. You can go ahead and you do the first reach out that, we're going to continue with the
plan,
with the payment plan. And then I will come up with the second communication, which we will deal with next week.
All right. I have it.
Okay. So, agendas 4 and 5.
Wait, before you get there,
Okay.
I'd like to make a motion, please.
Sure, go ahead.
I'd like to make a motion that all appeals be stored on the shared drive that Bill Flickinger's office is managing, where the letters are being stored, so that the entire board can be aware of what the residents are submitting, all of their requests. That puts all appeal letters in one spot for everyone to see.
We can do that on the.
It's a motion looking for a second.
I know, what did Diana just say? What did you say, Diana?
She
You
cut
cut
I
off.
was going to say that we don't always get the appeals in time for them to go into the data dump ahead of time. So there was going to be a time lapse, no matter if you do move forward with that, there's still always going to be a time lapse on that, because one of these appeals came in today.
Okay. So let's get back to Linda's motion. She's motioning that those should be put in the shared drive for every board of director to see. Can we do that even though it's a committee issue? We can, right?
I don't think it's a good idea
Why not?
because I think sharing people's addresses and their names and everything, I don't think
Yeah,
it's.
but this is only for the
That's-
board, right? Am I correct?
Right. It's in Bill's
just
office, so it's
It just
secure.
hasn't been used very well in the past, so I will not second that.
Well, I mean, now we have a directive saying it has to be stay within the board. We can't. Because this is the shared drive that's strictly for the board of directors, correct?
And it
Right.
secures the documentation for as long as the retention cycle requires it to be kept. It's all in one spot. Nobody has to go chasing around looking for it. Everybody can see it. There is no confidential information amongst board members. It's all available. And in having these conversations, it would be a lot easier if we saw the whole story.
I'm
My-
good with that.
Okay,
The
well,
appeals-
my way in is I don't think it's a necessary motion. And the reason I'm saying that is everything it's just all coming from, everything is already going into the share drive as part of the movement of data into the cloud. And this actually gets into something that we're going to have a discussion about in next week's meeting on Wednesday, because I perceive that we have, I'm not going to go off topic. I'll just put it on the agenda for next week. I think that's the best thing to do. Okay, so
sure.
do we have a second?
All right, so the second would be to concur with Linda on putting all the appeals on the shared drive with Bill. Correct?
Or I would just say that it
The
would be
drive,
the
the
shared.
drive where the letters go, wherever that turns out to be later
I
on.
don't see an issue with that. I'll second that. Yeah.
Okay. Okay. So do we have any more discussion?
I would like to say, Catherine, that I'd like to see us get to a place where all the district documents are stored in one server, one central location, so
I
that
agree.
they are available to everyone. And this is just a start to getting there, because right now on the Dropbox, no appeal letters that I can see are on the Dropbox, just the letters that are sent to residents.
Okay. Well, that's then going to be part of what we have to have a discussion about in next week. And we'll talk about that when we get down to that last agenda item. Okay. So let's go ahead and call the vote. Linda?
Yes.
Megan?
Yes.
Art?
Yes.
Beth?
No.
And I vote no too. Okay, so let's see, what is next? Oh, agenda items 4 and 5 are to appoint replacements for myself and Beth Jones. And I am just going to continue our term on the DRC. There are so many spinning plates right now. I think it's just easier for that we hopefully by the end of the current term that we're going to have, a whole lot of things will be resolved. Okay, so Bill, you included the documents for that. I will go ahead, print those out, sign them and scan them and send them back to you. Okay.
Yeah, that's Catherine. I want to just point out that during the pandemic, somehow the terms got unstaggered. We typically try to stagger these. Typically, they've been 6-month appointments, and we try to stagger them so that somebody comes up every 3 months. Because they got unstaggered, the documents I gave you actually have, if you appoint yourself to replace yourself,
Yeah,
that will come up again in July.
okay,
Beth's appointment to replace herself will come up in October.
okay,
So these terms will be restaggered, and of course, that's up to you. So
okay.
if you're okay with that and you fill those out,
Yeah,
sign
I'm
them,
okay with that.
scan them back.
Okay,
That would be helpful.
okay, that's fine. And so that's what I will do for numbers 4 and 5. Okay, now agenda item 6 is amendment of the residents' rights document. And this is a document that is used to, it's supposed to be in sync with the rules of enforcement. And am I saying this correct, Bill? And they've gotten out of sync. So we're trying to bring them up, bring them in sync. And Bill, can you, dang it. Can you share, go ahead and do a share?
Hold on, let me try.
I have the document.
Okay. I think I can bring it up. Hold on. Do you see a red line draft?
Yes, we do.
Yes.
And look,
Yes.
Catherine, if I may, let me give a little more background on why we're looking at this today. Is that okay?
Yes, please do.
Okay. So my recollection is that in 2006, there was an election and we had some new directors, including Lewis. And there was a concern that the enforcement being done back then by ST, now Infomark, was overly strict and unfair to the residents. So I believe Lewis had a lot to do with this particular document called residents' rights. And so I'm pretty sure this was drafted shortly after the 2006 election originally. It then became an attachment to the deed restriction enforcement manager's contract back when it was Real Manage and renewed with Real Manage and then ended up on Sage's contract. However, the problem is this document predates the revision to the deed restriction enforcement rules that added a category that we call friendly letters. So the rules were revised at some point to include friendly letters, but this document was not revised. And so there's a clear conflict between this document and what the rules provide. And the main conflict, it deals with the friendly letters, which are not designed to be formal notices that you can see in 3 little I's. I have an insert. It says the friendly letters are courtesy letters. The form of such letters is determined by a deed restriction committee. As such, those contents of those letters will change from time to time. And I'm saying in this proposed revision, the friendly letters are not formal notices. So a friendly letter could be sent, the deed restriction committee during the form. It's designed, the reason they call them friendly letters is it's designed not to offend people if possible. It's designed to get their attention on something of concern and possibly get a response. So as such, it's not going to have all of the formal notice provisions that the rules require. So the first paragraph little I just added a word. And then little 3, we just talked about.
Mm-hmm.
And then in 4, I'm calling it all formal notices of violations. And that's
Okay.
other than friendly letters.
Okay, so let me ask a question about 4 then. And so the last end of the sentence is to the underlying authority. And so in this case, who are we referring to? What is the definition of the underlying authority? Is that the deed restrictions themselves? Is that us? What is the underlying authority?
I think when Lewis wrote this, he would mean that you have to cite the declaration provision, the restrictions,
Okay,
the clause, and if there is a determination by an ACC, you would cite that as well. And
okay,
then this was written probably before the website was, redone over time, but they needed to be somewhere. So if they were in written form, they would have been, ST back then, or now on the website. So the intent of this is, if you write a formal notice, you tell the person it's a violation of this section of your declaration or restrictions, and perhaps a interpretation or determination, and where it can be found. And Megan has an item coming up that'll help a lot on the website. Where it can be found is those documents, and direct them perhaps to the website so they can go look at them.
okay.
So you would list the documents sections and let the person know they can go to the website to read them.
Tell me, is it appropriate to assume that everybody is capable of doing that? And I'm saying that is, at some point, we're going to stop asking the question. But have we reached that point?
I'm not sure what you're asking me.
Well, because we're talking about having the stuff on the website, and everybody on this call understands that's just a non-issue. But we know that we do have residents and people in our community that we're interacting with who have no concept of smartphones and the internet, and that is not going to work for them. Are we still under the obligation to come up with an alternative in that situation? And how do we document it? That's what I'm asking.
So I guess there's a couple things. One is the formal notice. The formal notice should cite the document and section,
Okay.
and also cite, if there is a determination, cite that.
Okay.
And, the declarations, the restrictions are recorded with the county, respective county. So a sophisticated owner could go look at the county records if they wanted to. Other people could go to the website and find it. The ACC interpretations or determinations, those are not recorded with the county. So we have to provide some way of them getting those. I think that if somebody says, hey, I can't go to your website, I need these documents, then I think we'd be obligated to make a copy and send it to them.
Okay. But we're okay with operating in the responding to a request.
Sure.
Okay. I'm just asking the question. Okay. Keep going.
So the next one, which is going to be little 5, I just changed it to all formal. Now, this provision that states consequences and failure, that is part of the rules. So that should not be a problem with the letters. Little 6, I changed this slightly, and you'll see it says formal notice violations clearly and specifically state the rights of the resident to appeal any violation, fines assessed, and the process to do so, which is in the rules. And the formal letters do talk about the appeal and how you can make an appeal. This last part, I'm not sure where it came from, and the rights of the resident to obtain delays in the enforcement process. There's really nothing in the formal rules that give someone a right to obtain a delay. Now, when you come in an appeal, that might be discussed. It might be discussed as part of your appeal, but I didn't see anything in the rules that talked about requesting delay. So I took it out. And then when we get to little 7, multiple violations part is not really, the policy of the multiple violations is not really in the rules to be required in the letters. So this is kind of something from the past that I don't think it's needed in this document. But when it's for a second or subsequent violation, then they get informed that it is, it's a subsequent violation and what will qualify for multiple. I think our letters are doing this on,
Okay.
if you don't cure it in this certain amount of time, you're going to get another violation.
Right.
So I think the letters do that. Little 8, accumulation of violations. Okay. So this just says that if you're accumulating violations, similar violations, a resident appealing it has the right to see their history of violations attributed to their address.
Okay,
And
so
I think-
that's where my next
Okay.
question was. Do we need to adjust the verbiage? Because this is about violations at an address for the account holder. Because, the account holder at the address is changing over time. And we're really talking about a specific account holder at a specific address. So do we need to be that precise? That's what I'm asking.
Well, I think the way it's written, it's okay, because if they're appealing a fine
Okay.
and the fine is actually against the prior owner, then you're not going to hold this owner liable.
Okay.
So I think all this is saying is, if you're saying you're fining me for multiple violations, I get to ask for that information. You got to show me the history on my violations.
Okay.
I don't think this would go beyond to a prior owner.
Okay. I'm just trying to, okay. So then keep going.
Yeah, there's one more. So little 9. This just says basically if you're fined for accumulating multiple violations, the resident should reasonably expect that the accumulated violations will be identical or at least similar. And that's what we do. We don't have escalated fines for different violations. They have to be essentially the same violation. And that's how we operate.
Okay, so then the last note that I had after I read this was, and this gets back to one of the accounts that we were discussing earlier, was who has the standing to appeal? Is it only the account holders? And remember, we had the situation today that we're talking about where we had people living in the house, people who own the house who were not the account holder. We had the situation in the past where the teenager was appealing the fine, and we said, ask your mom to appeal the fine. So do we need to write anything down about, or maybe in the rules of enforcement, maybe not in the residents' rights, but maybe in the rules of enforcement, that there are some standing that we want to enforce as it relates to who can appeal?
Yeah, so in our rules, we define violator, and
Okay.
we say that a violator is a person or entity determined by the district to be violating a restriction, or whose tenants, employees, agents, guests, builders, family members, or invitees have been determined to be violating restriction. So, and it says in cases where the property is rented, both the owner and the tenant shall be a violator, and both shall receive notices in the rules. So if you have a property that's rented, then the owner and the renter would have the ability to appeal, because they're essentially both responsible for the violation. Now, the person that has the water accounts can be mostly impacted because that's where the fines are going to go, but the owner is still responsible for them as well.
Okay, so did I hear an answer, a yes or a no?
Well, you asked me if the rules address it, who could
Yes.
appeal, and anybody that is a violator can appeal. So that would be the owner or the renter.
Okay. So So are we making the assumption then that minors living in the house do not appeal? That's what I'm really trying to,
Correct. I wouldn't
And-
take an appeal from a minor,
okay,
but if
Okay.
if a minor commits a violation, then the parent would be responsible for it.
okay. Well, so then we don't need to worry about any things that I marked down then. Okay. So, do any of the other board members have any comments about the adjustments that we're proposing to make to this document?
I do.
Yeah, go ahead, Linda.
The friendly letter is often the first contact a resident has with deed enforcement. Any suggestion that a property is out of compliance and in violation of the deed should always include the underlying authority in written form. All communications with residents deserve the same attention to detail as a formal letter. That is, it should clearly and specifically state the violation, including a clear and traceable reference to the underlying authority where it can be found in written form. This protects residents from receiving letters for things that are not contained inside of the deed. Doing so is a protection for the residents, and removing the requirement in friendly letters is a benefit to the contractor. It is imperative that we provide the underlying authority because it's in the best interest of the resident to know where it's written that they can't do something. I've already surfaced with the board before that receiving a notice that your property is out of sorts is an intrusion on one's privacy and can change the dynamics of a household in an instant. Moods can shift and the home is no longer a respite. It's an announcement that someone is watching your property and taking photos. The MUD board has heard repeatedly from residents about the impact these letters can have, and none of them have been pleasant. So to change the friendly letters to not include specific details where they should go to read about their suspected violation, that would be unfair. You could almost guarantee more letters to follow because they wouldn't have a way to go back and reference what anyone is talking about. I think the changes in this residence right document wouldn't be objectionable to me as long as these requirements apply to all communications regarding the deed, because we want these people to understand the restrictions outlined in their deeds. And in order for them to do that, they need to be pointed back to those references.
So you want the friendly letters to really be as formal as the next phase of the letters?
No, not formal as in these kind of things can happen to you if you continue, but more along the lines of you will find outlined in your deed in this particular location, this section, this chapter, this verse, the restrictions that we are writing you about today. So they can go back to their deed and see where those things come from. Or if it's an ACC ruling, point them there.
Right.
Whatever it is that's motivating the letter, it needs to be clearly identified to the recipient of the letter where this comes from. Otherwise, it just looks like a letter in the mail that has no authority and doesn't bounce back to anything. And it looks like junk mail.
I don't know. I don't know about junk mail, but I really want the friendly letters to be as friendly as possible. For lack of a better word.
And they can be helpful at the same time by pointing people to the reference that you're trying to cite.
And I guess and from my point of view, the definition in the friendly letters, I think would be pointing specifically to where to go find their deed restrictions on the internet and pointing them to where any interpretations that are coming into play might be. Now, Bill, I know that we're using the friendly letters to try to, to deal with the whole concept of pods. And, pods didn't exist in when the neighborhood was built. And so we're using the friendly letter as a way to say, hey, we see that you've got this, storage thing going on on your property, and we're cool with that, but it can't, and we're trying to move it through a process. So communicate with us, tell us what's going on about it, because we're not gonna let it sit there for a year or indefinitely.
That's an ACC interpretation. You could point them straight to it.
Well, well,
I mean, that would be your friendly notice, right?
right, exactly.
But you have to point them to it. Where did that come about?
Well, see, and that's just then, and I guess maybe that becomes another thing that we have to talk about, because the Jimmy and Dana, tell me if I'm correct, we're looking for we're not just looking at pods that are in Anderson Mill West. If a pod shows up in Hunters Glen or Valente Hills, we're going to treat it exactly the same, correct?
Yes, and we do attach the ACC interpretation in with that friendly.
Okay, so the question becomes, does the see, what I don't want is, I do not want us to be sending copies of deed restrictions as part of a friendly letter, because that's just going to be way too much paper going through. But I do think it's appropriate for the letter to include the location of where the specific section, because Anderson Mill West has got lots of sections, but the HOAs have basically got one set of deed restrictions. I think that it's an appropriate thing for the letter itself to contain the URL for for where the DRCs can be found on the web.
We do have that in the friendly letter.
Oh, okay.
And we do, you all have reviewed them. We do put section, the article number, the section, the title of it, the page, and then we just summarize it to keep it, short and friendly. So that
informal,
And that's, and Catherine, that is how it's working now. That is how it works now, but this change that Bill is suggesting takes all those details off the friendly letter and makes it only a requirement of the formal letters. That's what I'm objecting to. I want the same information in all the letters. The formal letters are more severe because it is impending doom. You're going to get a fine. We're going to cut off your water. That's the formal letters. The friendly letters are just an announcement that, hey, you might not be aware, but your deed doesn't allow X, Y, and Z. Here's where you can go read about it. That I want that information in the friendly letters.
Okay, and so really, in the end, what you're concerned about is that even though today all the pieces that you're talking about are in the letter, you're concerned that 2 years from now it might not be.
Oh, no. The way these, no. My concern is that you're changing the residence rights document that's attached to the Sage management contract only, to say that the details of the violation are only required in the formal letters.
Right. But right now we're all agreeing that these details that we're talking about actually are in the formal letters. Right. I mean, in the friendly letters.
Friendly, right.
But it's possible, because of how we're changing this, how this section 3 is being written, that the letters could change in the future to remove that detail. And that's what you're concerned about.
Well,
because-
I'm concerned that the changes literally make the details no longer required in the friendly letter, according to the red lines that Bill has
Yes,
got on the
yes.
screen.
Which red
Yes.
line, number 3?
Yeah,
it
it's
number
number,
three, Linda?
yes, yeah, the three.
Can I,
Everything starting from little 4 down
Mm-hmm.
now says all formal notice of violations, where before it used to just say notice of violations, which was the friendly letter as well. Now it says only the formal letters clearly and specifically state the violations. I want all the letters to clearly and specifically state the violation and a reference back to them.
Okay, Billy,
we
you were
just
gonna
fix
say something.
Can we just fix that by adding to new little 4 that just
Well,
says all formal and friendly?
can I interject something
Yeah,
here?
yeah.
Okay. Our problem is that this document was written before the current rules and it conflicts with the rules. And then it got attached to a series of contracts. This paragraph number 3 that I inserted matches what the rules say. So the rules do not require any specific detail in friendly letters. Now, I agree that the current ones look like they do and that they're doing what Linda says, but to keep this straight going forward, this needs to mirror what the rules say.
Okay.
Because if we start down that road of making this document different than the rules, then we have the same problem again someday soon.
Okay.
So
Okay.
that's why I said pursuant to the rules. So the rules say the content of letters are determined by a deed restriction committee. If we want to mandate a certain amount of content in the friendly letters, not only can we do it here, but we have to do it at the same time in the rules or very shortly after, because then we have a conflict.
Okay, okay.
So I'm happy to do whatever the board wants to do, but that's not what the rules say right now.
Right,
They don't
okay.
mandate that. Does that make
Okay.
sense? I'm just trying to make them match.
Okay, so clarify where the rule, these are the rules though, right?
Well, this is a document that was created prior to the rules being revised over time.
Yeah.
So it does not, I mean, this is a board document. This is not in our rules. It's attached to a contract. And, you know, I'm just trying to get them to match. And I'll be happy to write this however you like, provided we consider amending the rules to match this. So we don't
I think we should.
Can you just
Because you
take
can't
out the
fix something
words?
that you don't know where you're.
I'm
without
sorry, Art, go
specific.
ahead. Art, please go ahead.
Yeah, I missed you. I missed it, Art. Say it again.
I said, we can't have our residents fix something if they don't have the specific details of what they need to fix. So for example, right now, the friendly letter references all the violations and the deed restrictions that dictate those violations. I'm thinking of it personally for me. If I got a letter saying I had a violation, please fix it before you get a formal letter. I would want to know what that violation is.
Of course, it's a more technical point I'm trying to make, Art, is that, and I think I recall the conversation when the board wanted to have what they call friendly letters or courtesy letters. And they asked me if I could help write a friendly letter. And I told them, no, I can't, because I'm a lawyer and I don't know how to write a friendly letter. So we delegated that. No, I'm serious. We delegated that to the deed restriction committee to come up with a form letter that they thought was a friendly letter. So we didn't put any, back then we didn't put any requirements for those letters. And I'm not saying it's not a reasonable requirement to have little 4 apply to friendly letters. I'm just saying it doesn't match the rules. So we need to make these match. That's the whole point.
Okay.
I totally agree. So if we
Okay.
need
Now-
to rewrite the rules to match the friendly letter, I think.
I'm with Art. I think if we need to rewrite the rules, then we need to rewrite the rules. Not the residents' rights, but the rules.
Okay, so so I guess the question then, because didn't somebody, Megan, were you the one can say if we changed 4 to just say all notice of violations, would that cover 3 then too also?
Well, Yeah, or all formal add in and friendly letters. But then Bill's saying that then that's inconsistent with the rules.
So,
But I,
yeah, we could do that tonight, but we need to then look at the rules to make sure we're not, you know, you're gonna have to add that requirement in a friendly letter in the rules.
Does that
Okay.
change the contract for Sage or?
Well, it won't change it until we actually amend it. This was something that was an obvious first step in addressing the contract, that we had an attachment that was not, it was in conflict with our rules.
Okay.
And let me just add that this attachment, this exhibit B to the Sage contract, is prefaced with all communications from Sage would meet the criteria of these residents' rights, which is why you've been hearing me say for months, the letters are in violation of the residents' rights because of those granular details that are required in the letters. They are much better this month, but in the past, they didn't give you all the granular details that would be necessary for you to go back inside of your deed and find the violation. And that has been my complaint for the last 4 months. This effort to make this residents' rights congruent with the district rules is a great first step. I don't have any objection to it, so long as every friendly letter references back to the spot in the deed or the ACC interpretation that is driving that letter. In other words, no letter should ever be received by a resident that doesn't take them back to the source of the information that makes whatever they're receiving the letter about a violation.
I thought the letters.
Can we table this? Because it seems like we still have a lot of things that we need to look at. And
Actually, Beth, I think we're kind of close to a consensus. Let me make a suggestion and then you guys can tell me if we are or aren't close. Little 4, if we take Megan's suggestion and we after the words all formal notices of violations, we insert and friendly letters, and then we do the rest. We address Linda's, I think, primary concern. We make it clear that all the letters, we have 2 categories, all the letters do that. Our friendly letters currently do that.
yes.
And if we just change that paragraph, if we approve something like this tonight, then we can look at the rules when available to make sure the rules don't give the deed restriction committee this broad authority. We would say, something like subject to, including, the
Okay.
clear and traceable reference.
Okay.
I will say the one thing that, I know that the new friendly letters that we have been sending out over the past year, people really do not feel threatened by them. I think that they've, people feel open and honest to talk about what's going on.
Okay.
So I don't want to change it too much because I don't think that they're threatening at all. Just to make sure that we understand that.
Right, but it does sound like, I think little 4 is as how Bill has suggested, Bill and Megan suggested it.
I agree. I think we should do that.
We'll get
I
us.
think
I think we should change little 4.
I agree. I think
Okay.
that will help tremendously.
Okay, so
So why don't we consider a motion to approve this document with the change, the paragraph little 4, adding the words and friendly letters after notice of violations in line 1.
I'll
Okay.
motion so.
okay, so somebody give me a second.
I'll second that.
Okay. Well, do we have any discussion? Because we've had a lot of discussion. Any more discussion?
No more.
Okay, so let me go ahead and call the vote then. Linda,
Yes.
Megan,
yes.
Art,
Yes.
Beth,
Yes.
and I vote yes too. Okay, so hold on. What is next? Okay. Number 7. Then number 7, resolution authorizing the disbursement from the Anderson Mill West Beautification Fund. Okay, So have you sent us something, Bill?
Yeah, it's attached to the invite.
Okay.
This resolution is identical to the last one you approved, except for the amount. And the attachments are for additional attorney invoices. So the board previously approved a resolution to pay out of beautification fund directly to the attorneys. I think it was a little over 8,000 last time. So this time the amount is, I think the actual amount is $3,585, which will get current on the attorney invoices. And of course,
Okay.
it's subject to the same conditions, which if Andersonville West Neighborhood Association receives reimbursement of those amounts, either by agreement or judgment, that they return them to the district and goes back in the beautification fund.
Right.
And so this is just another series of, this is a resolution to get the next series of attorney invoices paid.
Okay, so can somebody make a motion?
Reading it. Hold on.
Were you gonna make a motion, Bill, Art?
Well, hold on. Didn't we do this before? But it
Yeah,
was
but
for a
this is-
different amount,
Yeah,
correct?
it was a different
Yes.
amount, right?
Okay, I motion so.
Okay. Is that sufficient enough, Bill?
Yeah,
I
Art,
motion that we approve the resolution of the Board of Directors, Williamson Travis County Municipal Utilities District, authorizing the distribution of beautification funds for Anderson Mill West Neighborhood Association to pay the legal fees of $3,585.
Okay. Somebody,
Sorry.
okay, somebody want to second that?
I'll second that.
Okay. Is there any discussion?
Yes, I have something to say.
Sure, go ahead.
The 2019 resolution that set up the disbursement of money collected from deed enforcement fines limits the recipients of this money specifically to the 3 HOAs and the Anderson Mill West Neighborhood Association, AMWANA. The resolution presented tonight states that AMWANA requested these funds when in fact the request came from a member of the ACC. If AMWANA controls the appointment and facilitates the operation of an ACC, as described in this resolution, then the AMWANA Executive Committee needs to be requesting any funds on their own behalf, along with an explanation to the people of Anderson Mill West on why this benefits them.
Okay.
The request was not made by Anderson Mill West Executive Committee. It was made by Chris Rocco, ACC.
it's my understanding, Linda, that Chris is actually on the executive committee too.
Oh, he is. That's
my
not
under-
published.
That's
anywhere.
my understanding. Yes,
And what is his position?
he's a member of the executive committee.
We don't know which position.
I'd have to double check. I think he does have an officer position. I think he might be treasurer, but I have to double check. He's definitely on the executive committee.
He's sitting on the board now?
Yeah, that's what I've been told. So I'm treating the request as coming from the neighborhood association, not the ACC.
Okay, so I'm going to go ahead and call the vote. Linda?
No, and for the record, to date, public funds in excess of $16,000 has been spent to defend this private social organization's mandates over properties in Anderson Mill West through a purported transfer of rights from the MUD to set up and house an architectural control committee. The MUD has no authority over any ACC and therefore could not give rights they didn't have over to AMWANA. Voting to pay for their legal defense is self-serving and a clear abuse of power, which is why the First Amendment to my lawsuit includes the misappropriation of public funds. That's my record.
So, okay, so is it appropriate in this case for Linda to be voting?
I sure can.
Well, isn't it, well, since you're the plaintiff, shouldn't you be,
No, I don't have to abstain from a vote. I'd have nothing to gain one way or another. And 3 members of this MUD board are directly responsible for the lawsuit. So I think if anyone should abstain, it should be the 3 members of.
no, I'm not responsible for this lawsuit. No, the only person responsible for this lawsuit, I think, is you because you filed it. But if, Bill, I take it even though it's an appropriate thing for her to vote on?
If Linda wants to vote, then she has the right to vote on it.
Okay. Okay, so there's nothing inappropriate. That's what I'm trying to understand because she's the plaintiff on the other side of what we're talking about.
No, the part that Linda was excluded from was the executive session that we had on the prior resolution when we discussed the legal aspects of this
Okay.
resolution. Linda's lawsuit, she's correct, her lawsuit challenges this process.
Okay.
But I stand by what we talked about in executive session previously. So.
Okay. Okay. Thank you for the clarification. Megan?
Yes.
Art?
Yes.
Beth?
Yes.
I vote yes too. Okay, so next we're gonna go to agenda, hold on, I got it wrong. Agenda
Wait,
number 8.
Before you move on, I'd like to make a motion, please.
Sure.
Before you move off that agenda item,
Yeah.
I'd like to make a motion that the expense records from all the beautification funds be published on the MUD's website for full transparency of where public funds are being directed. Is no one interested in full transparency?
Okay, let's take a vote.
You can't without a second.
Okay, then let's move on.
Okay, agenda number 8, request for accommodation of unique animals by the property owner on Hannah K. So, Bill, correct me if I'm wrong. At last month, we gave the property owner until this month to finish their, was it request for accommodation? And we heard from them?
Yeah, so to recap, yes, the board instructed me to write a letter to the owner and the medical professional, giving them 30 days to respond with the proper documentation or the request would be denied. By the time I got the letter out, the deadline became April 20, which is actually tomorrow. To date, I've received nothing. So if nothing is received tomorrow, then the request is automatically denied. We don't need board action. If something is received, we should have time to put it on next Wednesday's agenda. If anything comes in.
And okay, so let's make the assumption that we don't receive anything. So where do we start off? Do we start off with just standard deed? Do we start at the standard deed enforcement, the friendly letter, and then move through the process?
That would be my recommendation because we put it on hold pending this.
Okay, that's fine. So hopefully we will have heard something by Wednesday, by the next board meeting.
Well, the deadline's tomorrow, so if they don't submit anything tomorrow, it's automatically denied.
Okay.
And I can notify them that it was.
Okay.
If something is received, it would have to come in tomorrow.
Right.
Which would give us time to put it on the agenda for next Wednesday.
Okay. Okay. So communicate that to, if you issue a denial letter, then go ahead and communicate that to the DRC committee so that, and Sage, so that we know that we can start standard enforcement.
Yeah, what I'd probably do is just copy the entire board because the
Oh, okay,
board is involved in that, so.
okay, that's fine.
Would they be required to remove those unique animals?
That's what I think. But
Yes.
I mean,
yeah,
would that be in the letter that Bill sends? And then how long do they get to do that?
And then there's no, they don't get a grace period. It's going to be just however the enforcement process goes. You know, there'll have to be an inspection or some kind of confirmation they're still there and so on.
right. It's just going to start the
I mean,
regular-
we're not, I would not recommend after getting through this process, giving them, say, another 30 days to comply. That we'll just start. If it starts with a friendly letter, they'll have a little bit of time to deal with it.
Mhm.
And then after that, they'll go in the process.
Right. That, so to answer, so Linda, I think that absent no communication by the resident, I think that they're gonna have to remove their chickens.
I was about to ask, these are the birds, i.e.
Yep.
chickens, right?
Yeah.
Yes.
Okay. So first, and it didn't work. Okay. Okay, agenda number 9, deed restriction website pages. And I think this is Megan and Beth.
Yeah, so I'll share my screen. Let me pull that up. Give me a second. Get the right page here. So as I'm pulling this up, I hope all of you received the email from earlier today where I sent you all the link to this new page. Okay. Let's see. Can you see just the deed restriction enforcement
Yes.
page there? Okay. Okay, so again, just to reiterate, this page is not live. So the page that we've had for however many months is still the page that's on the public website. So we are seeking board approval tonight of the amended page, and then at that point it will go live. It would go live. So essentially what we tried to do with the page was to sort of rework it a bit to start with the assumption that whoever's visiting the page knows effectively nothing about deed restriction enforcement in the district, how the district enforces, who are the different parties responsible for enforcing, and then sort of tries to walk through that information for the person visiting the page. So it starts at the top with kind of a description, which is not on the current page, about generally just what are deed restrictions, the fact that all the neighborhoods in the district have deed restrictions, and what the district's role in enforcing the deed restrictions is and is not. And then also has reference directly to the statute that gives MUDs the authority to enforce deed restrictions. And then this is a section that was already there, and we just sort of cleaned it up a little bit, tried to make it clear that which of these entities are actually contracted with the district versus which are contracted with a homeowners association. So then we moved down to the deed restriction documents themselves. And one of the things that we added here is information on how to actually look up your neighborhood, if you don't even know what neighborhood you live in, and your section number. And previously on the page, on the current page, there is the district map But that map is confusing to, I think, every single person who's ever looked at it, because the front page has those page numbers and then people think that's their section number, and it's just a wildly confusing document. So instead, what we went with is just a direct link to the county's webpage where people can look up their property and find all the information on their property. And then with screenshots and with directions for how to actually look up your property. So hopefully this is explanatory enough that someone who's never used this page before, has no idea what they're even looking at, can go and sort of find the information that they're looking for. And then we do the same thing for Williamson County. And then we have the deed restriction documents themselves, and we tried to really, instead of lumping them all together, we broke them out into into sections by neighborhoods, so you can quickly and easy sort of find what you're looking for. Then we have the deed restriction enforcement rules, and the documents that are here are documents that are on the current page as well. We tried to clean up the names of the different documents, like this one, blockage of public sidewalks and streets. I can't remember what it's called currently, but something else that kind of wasn't really what the actual document was about when you went to the document. And then this document here, as I mentioned in the email I sent out, specific rules not enforced, is a document that info management is going to kind of work with Bill to continue to sort of flesh out and make more clear for people. But that document will not be updated unless and until we come back and get board approval for that separately. So for now, just the current document that exists is the current document that's on the page. We did add the rulings made by the Anderson Mill West ACC, along with a description of what the ACC is and what their authorities are per the deed restrictions. And then we included all of the rulings that we have on file. And then we have the section about review of proposals for construction or modification. Again, with some description of who reviews that. Now, the forms that we have here are still the current forms. They are in need of some work. So the goal is to go back and work with the different neighborhoods to get the form, make sure that they're fully up to date. But until that time, we have what we have. And then the driveway permit application is just something that's on the current site that we decided to keep here. And then I guess one other thing to mention here is under rulings made by the Anderson Mill West ACC, those are sort of the ones that we know of, and so those are the ones we've included, but we have included this sentence here, first of all, that if you're interested in ACC rulings from another neighborhood, to contact that neighborhood directly. And then in addition, we're going to reach out to those neighborhoods and see if they even have anything similar to this that they would like us to post on the website. But we figured that even though there are some outstanding things, you know, the goal is to have a sidebar menu over here, because there's so many sections that somebody coming to the page and they only see the top part, sort of see over like a library of what's actually on the page and jump to those sections. So there's a couple things. There's a link here that needs to be fixed right here. Click here to jump to the documents. That's supposed to jump you down to, if you already know your neighborhood section number, to right here. So that needs to be fixed. But we wanted to, because we think it's important that we move this forward and get kind of the new page up and going for residents, that we bring it forward tonight, as is with these other changes. So I guess, Bill or Beth, did you want to add anything?
I do not.
Yeah, I guess Beth, did you have anything?
No, I think once we add everything, I think it's gonna run a lot smoother than it has, so I think it looks good.
Okay. Well, the comment I have is I thought Megan did a really good job putting this together. I did meet with her and go through some of the aspects of it, refined it a little bit. It's much, much better than what we have up right now. We are going to have to revisit this from time to time, including the document she mentioned that talks about what the MUD does not enforce. Right now, we just have two things on there. We didn't have near enough time to propose an amendment to that document for tonight. So I recommended to Megan, let's bring what we have to the board, see if we can get this approved, get this up. It's considerably better than what's up there now. And it does include the Anderson West ACC interpretations, which is important for people to go to. I think there was some problem, well, more than one problem with transition from the old website to the new website where some things dropped off. And I think that might have been, the ACC determinations might have been one of those things. So anyway, I think this is really good. I think Megan did a really good job. It's not entirely finished on some of the documents will need modification, but I certainly would recommend the board consider possible approval of this tonight with whatever changes the board has.
So just for me, for my clarification, Megan, what you're going to ask us to approve is sort of the content, but you're going to make some improvements to the navigation. You know, by putting in this panel, this navigation panel on the left.
Yes.
Okay.
Working with contacting the other neighborhoods besides Anderson West to see if they have any rulings that they'd like us to post.
Okay.
And working with the neighborhoods to update their these forms for submitting proposals for construction or modification to your property.
Can you go up a tiny bit?
Yeah.
Okay. There's one I would add, but
What was that?
Sound, like loud, noise complaints. You only get it a few times a year, but I know it would be great to have the phone number on there for them to be able to call.
Because
are you talking about ACC rulings, Beth, or what are you talking
Yeah,
about?
like if people are doing bands in their garage at 11 o'clock at night or whatever, stuff like that. Who do they call? Because it's not the police. It's actually a different number.
Yeah, so
it would go into the same as what you have for dog issues or.
Well, those are ACC rulings, so we can't add ACC rulings unless they've been ruled on by the ACC.
We have something in there for sound, don't we, already?
There is something in deed restrictions about nuisances.
Yeah,
that's in the
deed
themselves. So those would be in the actual deed restriction documents.
What I'm hearing, Beth, is that we need to maybe put what you're talking about someplace else on the website. Who to call for when, if somebody were to come to our website because they don't know who to call.
Yeah, we have that in our little area here, and people ask me all the time, who do we call? I'm like, not the police, they won't come. They will, but they don't want to. Let's just say that.
Yeah, I agree. There needs to be more information on the website about who to call for what, and how to report all sorts of things. And I am only, I'm like doing over. I've got so many, so it's taken a while. So, but we talked about months ago, bringing forward the changes to the deed restriction page first before anything else,
Right.
because this is kind of the most important thing to get squared away.
Okay.
Well, I like the format. I like the links. I think it's very well organized. I haven't read all the content. So if we're approving this for the format and for the the way it's organized, I think it looks great. It's
Yeah.
great.
Okay, so somebody want to make a motion then?
I'll make a motion.
Okay,
I'll
make a motion.
second that.
then.
We
No,
go
who made the
ma-
motion?
No one.
Yeah, okay. Okay, I'll make a motion then. I move that we adopt the content on the deed restriction enforcement page as presented to the board tonight.
And I'll second that. How's that?
Okay. Is that going to be sufficient, Bill? Because we're really talking about content, and we're not going to need we're not going to go through this again because they're going to be, making the navigation better. We're not approving that kind of granular detail. We're approving the content, correct?
Correct, and authorizing it to go live. 'Cause it's-
Oh, okay. Yeah, and authorizing the content to go live. Okay, let's make sure that that's part of the motion. Okay.
I'd like to discuss, please.
Yes, please. Let's go ahead and discuss some more.
I have no objection to the way it looks. I do have a problem with the content because a lot of those AMWANA rulings, ACC rulings, are not even executed documents. And nowhere in minutes can I find any board approvals to adopt those interpretations and turn them into violations of the deed. So those things have to tie together. Some board had to have approved adopting those interpretations, and I can't find those. And every document that's published here needs full signatures and dates. And if you look at those ACC interpretations, a lot of them don't have that. So those documents aren't valid, and the board approval to adopt them is missing.
All right, so
So-
Bill, what's your response?
Can you please answer?
I'm sorry.
Let him do it.
Linda, can I ask a question on your comment? Okay, so when you say there needs to be a record of a board adopting the interpretations, are you talking about the MUD board or
Yes.
the? Okay.
No, the MUD board.
Okay.
Because the ACC can make all the interpretations in the world, but the MUD board does not necessarily have to enforce them.
Correct. I
So
think we addressed that in the current DRC enforcement rules, where, and I can dig it out in a second, we have a provision in there that basically says, unless directed otherwise by the board, the deed restriction enforcement manager will take into consideration all rulings or determinations. I'll have to look up the language of an ACC in its enforcement. So I think we covered that in the rules. As far as the formality of the rulings made, they're not perfect, I understand, but this is what has been published by the Anderson West Neighborhood Association as their adopted rulings.
Right.
So even if even if they're not signed, even if they're not as formal as maybe I would like or you would like, this is what they have presented as adopted. So I don't know that we can go back and mandate how they adopt them or how they formulate them. In fact, I'd be uncomfortable doing that.
Well, they're just willy-nilly little edicts on how people are supposed to live on their property. And as you know, because of my lawsuit, I don't think they have the legs to stand on with that. So I'm just saying, if you're going to put it out there on this MUD website and make it an official thing, then it needs to go through all the process of being official. If people are going to be fined for these things and have their water turned off for these things, then it needs to be approved by the board because it modifies the deed. A lot of these things are not in the unsightly articles, which is the only part of the deed that lends itself to interpretation in the first place.
I'm thinking how, as far as a legal response, I think we have addressed the MUD board approval essentially approval of ACC determinations in the rules. Now, the specific ones, I have not studied all these. In fact, I just saw them, I think, a week or two ago. I don't think they're all particularly well written, but they do exist and they've been promulgated. So the MUD board could direct the deed restriction enforcement manager to not follow some of these for any particular reason, but to date we haven't done that. So I would kind of reverse the process you're talking about. The determinations are assumed to be valid and to be followed unless otherwise determined by the board. And this would apply not just to Henderson West ACC, we have those, but any other HOA that has an ACC that makes written determinations, whether it be for unsightly or other things within their jurisdiction.
Yeah, but HOAs have authority over the ACC. The MUD does not have authority over an ACC. There's the difference.
The MUD board does not have authority over any ACC.
Exactly.
My
I'm
opinion.
saying, so if the HOA writes interpretations to the deed, the HOA's ACC, which is typically the same people, if they write interpretations to the ACC, they have the authority in their HOA contract to do that. The MUD does not have the authority over an ACC. So when you put these things on the MUD website, you take responsibility for them. I think it's a huge liability. I don't think they
Well,
need.
we can do this two ways. We can just say, go to the Henderson West neighborhood site to see the determinations. However, that makes it more difficult for people that are trying to figure out how we came up with the restriction violation, because we just talked about the residents' rights, and we're going to talk about the rules at some point. We want to make it easy for people to get to these rulings because some of them are the basis for the letter they receive.
Exactly. And I'm not suggesting that you shouldn't. And a link to the AMWANA's page is as easy as putting them here. It just doesn't make the MUD liable for those decisions.
I don't think that it's as good the neighborhood association's website is only going to be available subject to resources to fund the website. So given their limited resources, I can't, what if the neighborhood association's website goes away in 3 months? Then these are not available to anybody. So having them here is having clear public record of what.
It's like advertising for AMWANA, and I don't agree with that. Just like we're not putting the HOAs stuff up there. So why?
Linda.
I heard you say you
were
Megan,
with them.
Megan, you've done a great job. Let's take a vote.
Well, let me interject. I mean, Linda's making some points that are really at least partly legal questions. So I don't think that putting these on our site by saying these are interpretations that are used to help enforce restrictions is necessarily exposing the district to any particular liability. We're providing information. If we have similar rulings or determinations from the other HOAs, we're going to put those up too, presumably with, Megan would come back and provide those to you, because the whole idea of this page is to make it convenient for the residents to get to these documents. And so I don't see a real legal problem with putting them here. I think Megan's probably right. If we link them to another website, then I don't know if we're really following the residents' rights that we just approved to make it.
Of course it is, as long as you have a quick and direct link to the information. It doesn't matter where it's stored.
Can we call?
Yeah,
for a vote?
I'm ready to call the vote. I'm okay. I'm just gonna say this. I'm okay with how all of this is put together. My understanding and, recollection about how all of these interpretations came about was it was the MUD coming back and asking for guidance because they needed to understand, well, okay, what's the definition of an unsightly yard? And that's how we came up with, 8 inches for, I think that's what the yard maintenance says. And, Lakeline Oaks came up and said it was 2.5, I mean, it was just, how the neighborhood decided to put it together. And so at one point when we were doing Lakeline Oaks, you had one interpretation for Lakeline Oaks and you had a different interpretation for Anderson Mill West. So I agree. I think the whole purpose of the interpretations are to aid in the process. Okay, I'm going to go ahead and call the vote. Linda?
No, and for the record, putting documents generated outside of this MUD's authority on the MUD's website are endorsing those documents, and I do not endorse those documents.
Okay, Megan?
Yes.
Art?
Yes.
Beth?
Yes.
And I vote yes too. Okay, can you stop sharing, please?
Yes.
Okay, and
Who did the motion on that and who seconded?
I did the motion and I think Beth seconded it. Okay. Okay, number 10, minutes from the prior DRC meetings. I don't think we have any, am I correct, Bill?
Well, I think we're waiting for the DRC to review
Yeah.
the other drafts.
Yes.
As far as sufficient detail.
Yeah.
So I didn't put anything out there. I was waiting to hear back.
Correct. Okay. Agenda item 11, deed restriction enforcement actions pending with district's attorney. That must be you, Bill.
I think we talked about the only one that we had any update on.
Okay. Agenda item 12, future board meeting schedule and scope of agendas. Okay. One of the things that I would like to put on the a meeting from a week from Wednesday is that we need to have a discussion as it relates to email with third-party vendors. And specifically, I'm talking about Infomark and Gray Engineering and Bill and whatever vendors we have. And the reason that I'm bringing this up is that Infomark has a policy that when one of their employees leaves, within 30 days, they remove all of the email from their systems for that employee. And when they did that with Patricia a couple of years ago, we lost an unbelievable amount of institutional knowledge about what we had been going on for the last 5 years. And those were technically our documents. So we need to come up with a plan in terms of how our vendors are archiving our email with us and between each other as they're dealing with our account so that we don't lose anything. And so we need to put that, and we've got, I think we've got the technology committee is, who would that be under? Isn't that, because I see this as the same subcommittee, was it Art and Megan who's dealing with the Google Drive?
Yes.
It is.
I'm trying to think, what is the name of that committee?
It was a special committee.
Modernization.
Records modernization. Okay. So I'm just going to throw that out there. Let's put that on the agenda for a week from now so that we can get that, on the horizon. I'm totally clueless as to what the path is for that. And the reason I'm bringing it up now is we may need to budget some money for it, and to come up with the process. That's all I'm saying.
You want a process for a third-party vendor i.e. Bill or Infomark or
Gray or
Engineering
Sage, because we've got to come up.
for records retentions and email retention. Is that correct?
Well, yeah, I'm not concerned so much about records retention because because we need to have a process for that too. We've got Sage that's, moving things on a pretty regular basis. But I'm really concerned about it from Infomark's point of view. I don't want us to have another situation where somebody leaves and all of a sudden we lose all of the email communication that ever took place, because like I said, those are our records. They are not theirs to remove, to get rid of. They fall under our retention policies, not theirs.
Why isn't that written into their contract? Wouldn't that be
Well,
the best way to handle it?
I'm not going to argue that, but at this point, I don't know what the solution is. That's what I'm more concerned about right now, is what is the solution? Because
Well, that's one solution. We can amend the contract and put that as a stipulation that all employees that.
Yeah, well, let's put that on. Let's a week from now, or 10 days from now, a week from Wednesday.
Okay.
So that's the only one that I'm aware of. So are there any more that anybody knows that they want to add to the board meeting?
This is for not this coming Wednesday, but next week, Wednesday?
Yeah, next week, Wednesday. That's what we're talking about.
I would like to add, again, this will be the third time I've asked for it. I want to discuss the rate order, and I want to discuss it as it relates to locking it in for seniors, just like school taxes, MUD taxes locked in for seniors. I want to take a serious look at that and see what the impact is financially. There's only 250 seniors in the whole district, so it can't be that much.
Linda, that technically is not the rate order. I mean, you're talking about the property taxes.
I'm talking about MUD taxes.
Yeah, the taxes, not rates, taxes. So we don't set the taxes in the rate order. We set the taxes once a year. So if Catherine approves it, we could have an item to discuss creating essentially a tax exemption for persons over 65. I think I can double check, but I think there is actually one right now, $3,000 exemption, but I'll double check. We can have an item to talk about it. I think there's a $3,000 over 65 exemption for the district that was adopted a long, long time ago. It's being, but it doesn't have to do with the rate order. The rate order is not where we do it.
Then I've misidentified what it's called. I know the rate order applies to taxes, so I'd like an agenda item to discuss creating a tax exemption for persons over 65.
And Linda, we need to talk about that also in terms, from a budgeting point of view.
Exactly, and that's why I know how many people meet that criteria, 65 or older. And now it's just a matter of linking it back to their MUD taxes and what they are today, what that would look like locked in, and going forward and using average life expectancy and see what that would do in numbers financially. What would that look like financially? Because remember, everybody around them's property and tax values continue to rise. Okay, so the 250 that would be locked in, there's still people around them rising up. But we can talk about it if it makes
right.
Now, there's going to be a couple issues. One is whether we have anything now, which I can check on before the meeting, and what we can do legally as a MUD. Catherine, you all right putting it on the agenda?
Yeah, I'm totally okay putting that.
So we'll have it on the agenda and we'll discuss in more detail on Wednesday.
Thank you. Also, I wanted to also add open records requests back in to the packet, the financial packet, the spreadsheet that Bill used to create. I'd like to pay closer attention to the record requests that are being asked for and how long it's taking to fill them. So that's another something I have on my list that I think needs attention.
So it's no
The
longer part
rules
of the
order?
it's no longer part of the management report? Is that what
No,
you're saying?
the spreadsheet came out of that package for some reason.
Okay.
So I'd like to see that put back in.
I would
There's-
also like to add on there on what we're gonna accept and not accept of people in the neighborhood sending us stuff on deed restrictions.
I mean, as far as complaints, is that what you're saying,
Yes.
Beth?
Yes.
Now, Linda, going back to your comment on open records,
Mhm.
there's really two people. One is the spreadsheet on the requests and the requests that have been fulfilled that my office prepares. Is
That's
that what
right.
you're talking about?
Yes, that's what I'm talking about.
So that was never part of the manager's report. That's something that we provide.
Yes, but it was delivered in, oh, was it separate from the report? Okay. Okay, keep it separate then. I know it happened right after within Michael's conversation.
Okay.
So that.
Okay.
I still want the rules of order that I submitted in early March. I want those put on an agenda for consideration. And I really, if I only got to pick one thing, I really want the bills being presented in the 87th legislative session that impact MUD districts. I want to know what those are now, not after they've passed.
Well, okay. Well, so let me ask a question then, Bill. When have we finished? We finished the filing, right?
What filing?
Well, isn't there?
Oh, the filing deadline.
Yeah. So
No.
everything that's possible has already been filed, correct?
Correct.
Okay.
So I'll just tell the board very briefly because it's not on the agenda today, but historically, we have not spent a lot of effort tracking pending bills for the MUD. The MUD really has not engaged a lobbyist to affect legislation. It's been done by the trade associations and so forth. So when we had active board members on like
Case AWBD.
AWBD, they would be doing a lot of that tracking and information for us. I'm assuming that perhaps that can be accessed. I don't know, Catherine, if you're active with them. So we certainly, as the law office, we certainly can tell you what bills are pending, do a search for all the MUD bills, but many of those are not going to pass.
Yeah.
And we may have little, I mean, if the board wants to get more active, we might have little impact on them. So I haven't spent a lot of time and I haven't attempted to figure out which ones are pending yet. I mean, I can do that. And, you know, if the board wants to, but once you have the information, that really doesn't give you a lot of feedback on what's going to pass. Things go through the committees, obviously. So if it hasn't made it through committee after a certain time, probably not going to pass. We did come across at least one proposed bill that would require all MUD board meetings to be recorded. And the good thing for this MUD is you already set up, when you go back to in person, you have recording equipment and so forth, but a lot of MUDs don't have that. And there might be other things. So, I mean, I'll be happy, Catherine, we certainly can put it on the agenda. We can talk about it.
Right.
But I don't know that I'm going to have a complete report next week. Maybe it might be something we track monthly.
Well, what I was wondering is, let me, I know that Case and AWBD, let me go ahead and look over the AWBD website and see if there's something out there that we might be able to pull in, because I don't know, AWBD is the big trade association that's doing a lot. That's more active in monitoring that.
Well, you know, Catherine, I thought the same thing. And so I went and looked and I could find nothing on their website, but I know that we just recently paid them close to $700 to be a member of this organization. And they did hold a winter meeting in January that nobody attended. And since they are the ones that drive the bills through the legislature, it would be really useful to know up front what they are proposing for MUDs. Whether they pass or not really doesn't matter. If we know about them up front, we can lobby legislators ourselves. We don't need to have a lobbyist to get things either turned in the right direction or considered or supported. There are other ways to move legislation without a lobbyist.
So Catherine, are you going to check on that?
Yeah, I'll go ahead and contact somebody in AWBD. I'm wondering if they might have something that they can share with us.
Yeah.
I'll put that on my list of things to do.
They might have materials from that January meeting that they can give you.
Okay.
Too, they will send you emails, like they send update emails. Like I know I've gotten emails where it was like, this bill, sign the petition for this if you want this to go through for bills that relate to MUDs. So
Right.
there may be something in those emails too that's of value if you want to keep track of that stuff and register your email address with them.
Have you done that?
I've done that. Yeah.
Okay. Well, obviously I must have because I'm getting emails from them too.
I'm sure you have. Yeah. I would think you have.
Yeah. Okay. So we have anything else to add to the to next week's agenda?
Not for me, thank you.
Okay. So somebody give me a motion to adjourn.
I motion that we adjourn this meeting.
I agree. I will second that. Everyone say aye.
Aye.
Aye. Aye. Okay. Everybody have a good night. I will talk with you on Wednesday.
All right, we'll see you Wednesday.